Dorrit, we're going to talk about the relationship over the years between the English legal system and the Israeli legal system. We thought, Dorrit, that was an appropriate way to celebrate the 75th anniversary, because the purpose of the Lionel Cohen lectures over the years has been to reflect on and to celebrate the links between the English legal system and the Israeli system. And Dorrit, there's no better person, we thought, than you to...
You'll find many better people here.
And you were available. And no, there was no better person. No better person to reflect. Of course, you don't go back, I should emphasise, to 1948, but you go back a few years. And shall we start at the beginning, which is not, as the Dean suggested to me earlier, Genesis, but let's start more recently, 1948, long before your legal career. But, I mean, am I right in thinking that in those days, many of the judges and the lawyers in the New Israel had been trained in law in the United Kingdom, in London?
Of course. The first president, Samoa, is Justice Olshan, and later, even later, Justice Heshin, where we sit here, all of them. Landau was the president of the court. They all there were trained in England, of course.
And when you started out, what sort of textbooks, legal textbooks, would you have on the shelves in the offices where you were working? Were they
Yes.
Israeli or were they English?
We had no Israeli, I must say, and it wasn't 48 when I started. No. It was long ago, but not 48. So then, I think every field was only English textbooks. It was Salmond on jurisprudence, it was Archibald in a criminal procedure, yeah. It was Glanville Williams in criminal law, everywhere. Of course, torts, evidence, all the books. And talking about administrative law, it was the Smith that we opened before every case we came to the court, when I argued in the court for administrative issues. First of all, the Smith, Wade only, I must say, all our textbooks were in English. So practically you can say that even in the 60s, what I'm talking about, the training was actually on English.
It doesn't sound very different from being trained as an English lawyer in England. I mean, those were the textbooks that I would use a little bit later, but not too much later, when I was trained. I mean, do you think there's an irony here? Because 1948 was the culmination of a struggle, an epic struggle, for the independence of Israel from the British Mandate. And yet, in legal terms, the influence of the United Kingdom of London persisted for many, many years.
Many years.
And it is quite extraordinary. I mean, prior to independence, long before the memory of anyone here, the final court of appeal for the British Mandate was, of course, the Judicial Committee of the Privy Council, which then sat until 2009 in Downing Street. And so the appeals would go from here to London. I've done my research. There's a Judicial Committee case in 1926, Jerusalem Jaffa District Governor versus Suleiman Mara, where the Privy Council held that by reason of the League of Nations mandate for Palestine, His Majesty had jurisdiction over Palestine, and so the Privy Council was the final court of appeal. Yes. And they decided, the case was about the district governor having power by ordinance to take water from the springs of Urtas village for the purposes of the inhabitants of Jerusalem generally. And the Privy Council, a remarkable institution, because in those days it was the final court of appeal for much of the world, for India, Canada, Australia, not just Palestine. Remarkable.
Yes, it is. When you think about it, during the British mandate, while the Jewish population was fighting against the Brits, actually, accepted the British system and respected it. I think it started really before the state was established. Ben-Gurion had the idea of the English law. He admired it. He was there during the war, World War II. So in the history, it's kind of strange. I thought about it. While fighting, all of the basis for our law. All the ordinances were respected. And of course, we will talk about it probably, a reference to the judgments, the British judgments, to the common law, to equity principles. It was all accepted, naturally accepted. And some of the ordinances are still here, they still exist.
It's rare, in my experience, for judgments of the Israeli Supreme Court to be referred to in judgments of our appellate courts in London. It does happen. I mean, the most celebrated, the most often cited, I think, was Justice Barak's judgment on torture, which has been cited in any number of cases. But there are other examples. I mean, 2 years ago, I was arguing for the government in the case where they wanted to remove asylum seekers to Rwanda.
Yes.
And the Supreme Court, our Supreme Court in London, was very interested in the Israeli experience, and we cited the orders that had been made by the Israel Supreme Court. I don't think there was a narrative judgment determining the issue, but there were procedural applications. Is it still the case in your experience over the years when you sat as a judge that contemporary judgments from London were still cited in Israeli courts?
First of all, I think they're still cited. When you say how our judgments were cited, I remember once I was very impressed that you asked me, what do chicken growers have to do with constitutional law? Someone, I don't think in Congo, somewhere someone cited the chicken growers.
Yeah.
And David asked me, what does it have to do, chicken growers, with constitutional law? So we had it.
And there was another case about prisons where...
Yes, privatization of...
I think that was your judgment, wasn't
Yes.
it? Privatisation
Yes.
of prisons, whether that was constitutionally appropriate.
Yes.
That was relevant in an English court. So the English courts are willing, eager to learn from the Israeli Supreme Courts. In Israel, courts' decisions in London are still cited.
The thing is, I think things changed. I mean, until 1980, we were really, even by law, connected to the judgments and the principles of law coming from Britain directly, because of Article 46 of the King's Order in Council of Palestine that was in force. So we were bound by it, and we respected it. We accepted it. That's what I say, always good. The British courts, citing our judgments, I think it became, or showing interest in our judgments, it became stronger when we had the exchange between two delegations, the judges from England and the judges from Israel. We met every year, actually, once here and once there, and we learned the judgments and the way of thinking of each other. And since then, your judges were more interested in our judgments than before. So the shift changed later. But we still, I must say, even the fact that I think the last 30 years, if we can say so, we refer more to American cases, Canadian cases. This is a change in our judiciary.
Why is that? Why has Canada and the United States become more prominent in terms of Israeli law?
Maybe people sitting here are to blame because the academic world went to the United States and Canada. Canada was also because when we introduced the law of human rights and dignity, we were influenced much by the Canadian Charter. So we introduced more Canadian cases that interpreted the charter.
Yeah.
But America, very simple. The academics went to study in American universities. They were interested in articles that are published in the United States. They had to publish themselves. I think now, I'm not sure about it now, but at that time, this is part of it, part of the development. I mean, we were trained actually, even with, not in London, here, by English law. This made us a common law. We are a common law state since then, actually.
Yeah.
But we had access to the American judgments, and things were changed. As I say, maybe people here can explain it better, but I think this was the beginning of the connections with the United States and Canada, and it changed. And the judges of the last 20 years were not really trained in England anymore.
No.
So it's the legal training was changed, and the legal way of thinking. We were more open today also to the continent in certain issues, but this is part of the change in our legal, and I think people here can tell much more than me about it, how it happened.
Yeah. But I mean, despite that change, my perspective is that the English legal system and the Israeli legal system still retain and value very similar principles of law. I mean, one can state obvious ones: independence of the judiciary,
Of course.
the rule of law, the protection of human rights, the need to prevent corruption by officials and by ministers. I mean, from my point of view, but
We are
these
talking about theories.
I mean, these are principles. Whether they're respected or not is another question. But there is, it seems to me,
It's true.
a recognition that these principles are fundamental to a legal system, and they're common law elements. No doubt they're also to be found in the United States in principle and in Canada. But that's because they have been
Derived from the
affected.
same origin.
Yeah,
After
yeah.
all, they also started as
Yeah.
a common law state. So
But that's true of Israel, is it not? I mean, despite the movement
no,
away,
it is true. I mean, as I said, first of all, we became basically a common law state, as a common law system. The role of precedents, of judicial precedents, the rule of law, as you said, all the principles, independence of judiciary. I hope that in most democratic states this is still the basis. I hope so.
Yeah.
So also, of course, judicial review. After all, we took the idea of judicial review from your system, developed, I must say, it developed. It started completely, as I said, before going to the court, I used to take the Smith and to see what to say about this issue or the other. The rights, freedom of expression and rights of association and the press, the British ordinance of the press was abolished here only in 2017. Until then, you needed a license according to the ordinance of the press. Many of them still exist. They were revised. You see, the tort law, the torts are still, we have the same ordinance with a Hebrew and amendments, but basically it's that. And how do we have negligence? We go to Donahue, we started, and everything like that. You see, when I came to argue, not a very present, laws against terror, of course, the defense regulations from 1945, part of it still exists. I remember when I came to argue a case for the state on administrative detention. And then Justice Usman says to me, Mrs. Bainish, what is the problem? You have Liversidge. And I didn't know who is Liversidge. What does he want? He said, but you know, it's Liversidge. You don't have to argue the case. It's very simple. So
You thought he was talking about liver sausage, did you?
No, I understood that I have a problem, but he wanted to say that I have no problem. So this is actually the case, and in many cases. Then
this
we
is very
cite it.
true of other jurisdictions that started off with British ordinances or rules, some of which still remain in India, in Hong Kong, in other jurisdictions that where independence was gained. And the principles are developed. They're developed according to national characteristics, but the basic principles remain. I mean, there's one fundamental difference in criminal law, which is you don't have juries, do you? I mean, juries in England, they're sacrosanct, and every so often there are political proposals that the jury trial should be cut down, often for financial reasons to speed up. And it's very sensitive at the moment. But here you don't have.
Luckily, we don't have the jury system, and this is also the Brits to blame, because they didn't trust the population here. So they thought it was the idea of course, of jury system is a democratic idea. The people are involved. But who are the people then? When you had the Jewish population, the Arab population, and the British tribe.
The British didn't tell you that Lord Devlin said that the jury system is the lamp by which freedom lives. Didn't tell you that?
No.
No.
No. So they didn't accept it, and this was the reason, historical reason why we didn't have the jury system, because the basic idea of a jury didn't exist here during the British Mandate. And so they had the professional judges, and you mentioned the Privy Council and other. When it came to London, it prevailed. The government was always right. Here, the Supreme Court was more a professional Supreme Court, but most of the judges were British at that time in the mandate. They didn't trust the population.
We've got a question.
Not a question, a comment.
Comment.
Professor Al-Zamir, Professor.
Thank you. So I agree that in some areas, like tort law, we are still part and parcel of the common. But this is not true in many other legal systems.
Contracts changed.
Good,
Of course.
yes.
It's your field. It's your field.
My area.
Yes.
Usually in private law, we are a mixed legal system.
Yes.
And so we have influences from both civil law and common law systems. And even more importantly, now that we are that we came of age, we are an independent legal system. Unlike the Israeli system 30 or 40 years ago, we are an independent legal system. So we are inspired by any other legal system that we can rely on, including the British, but we don't give any special status to
Of course.
the British law.
But no legal system is an island entire of itself. All legal systems are influenced, affected by issues in other courts. And it's true here, isn't it, as it is in England, that very similar issues arise, whether it's private law or public law. I mean, we all have cases about how do you deal with terrorism and reconcile that with human rights. To what extent do you defer to the executive in judicial review because they may have expertise in relation to particular topics? And the case law of different jurisdictions is not binding, but it does influence the courts.
Of course.
We are the champions of thanks to our relatively young age, we are the champions of comparative law.
Yeah.
More than any established legal system.
Because you are affected not just by the common law, but the civil law tradition.
And because we don't want to reinvent the wheel.
Yeah.
We don't have to, yes. But Eyal, it's true where we have our legislation. So in private law we have more, as you said, and in public law we developed, we didn't remain in the British way of thinking, I mean developed of course of actions, but basically public law is based still on the concept of the Brits.
Yeah.
I think so.
Yeah, the question.
If I may add,
Yes.
I taught a few years in the UK, and I was always interested in administrative law. And teaching in the in directions that the British system still hadn't done that.
We were quicker in that, yes.
Yes, we were earlier before
Yes.
Baker versus, no, not Baker versus Carr, that's United
No,
States.
that's United States.
But there was such a similarity, and there still is. I explained in the class how our grounds developed on the basis of the British system of legality, and how they grew and developed and flowered or whatever.
Yeah.
But it's still very, very similar. So it depends if we're talking about topical.
Yeah. It's a cultural thing, isn't it? It's the extent to which a legal community is open to influences. And I think my perception is that the Israeli system is particularly open to the experience of other jurisdictions by way of information, whereas, at least until recently, and perhaps even now, the United States system is a very closed system.
Of course.
You very, very rarely see counsel in a Supreme Court case, constitutional case, cite the experience, and it may be on a very similar issue, of the European Court of Human Rights, or the Supreme Court of London, or of the Israeli court. It's a cultural thing, in the same way as the Americans don't join international organizations. But my perception is Israel is open to these influences.
Every legal system is, of course, inspired and developed through the culture, the history, the background of the state. Of course, the Americans, they want to make America great again all the time. So what happens? They really don't accept. You don't cite judgments from other systems in the Supreme Court. They don't in their judgments. Some of them, very few, and I don't know how now, but did it. But this is different the way we were used. You know, almost every issue, everything that comes to the court, we stop to think, and how did other countries solve the problem? And we have all similar problems, of course. So this is basically not only for the judges.
No.
And people know when they argue a case in court, they have to bring, if they have examples to show how other systems solve the problem, they do it. And,
Did we have another comment there?
During the first decade of Israel, we were completely citing English authorities, but we translated them to Hebrew. If you read the judgments of it, that's the thing. First decade, it was very important for the Israeli court, for the Israeli society to talk Hebrew. It was a sign of independence. So you could see the English judgments translated, cited, but cited in Hebrew, and then they figure out that it's too costly or too cumbersome, whatever, and then they move to straight citation in English.
they had less access to it. Yes, it's
Became
true.
more confident about the language, perhaps, or whatever. The second is about the Americans. Paradoxically, the Americans are not citing any authorities, but American administrative law, current American administrative law, is back to the ultra virus principle. They just don't call it that name. They call it major question doctrine. It's the same principle.
Yeah.
So the English principle of legality is basically, I think, controlling the world of public law. In Israel, it gained a constitutional status by recent decision of the Supreme Court, and not only in Israel.
Yes.
So this is, even if you don't cite UK authorities, the idea of legality as such is probably, and the UK idea, the ideology of ultra-virus ideology, is probably the ideology that controls almost any system around the globe as a constitutional principle today.
Yeah.
Yes,
Yeah.
it's
I mean,
true.
on constitutional principles, which you turn us to, there is, isn't there, Dori, a real distinction between the United Kingdom and Israel in that we have in London checks and balances which are very effective in practice. We have a second chamber of Parliament, the House of Lords, which has considerable delaying powers and considerable powers to make the government think again and to raise issues which the government may not want to consider. And that is a very real effective control on arbitrary power by an executive which controls the lower house of the legislature. And you don't have that, do you? You have a unicameral legislature which makes the role of the other main check and balance, which is the judiciary, even more important.
Of course, we believe in it, that this is the only institution that can review and to protect the checks and balances. The problem that it's not accepted so much, not by the executive and not by parliament, who is, of course, controlled by the government because of coalition.
Yeah.
So it is true. But I agree that basic public law is really, we have in common with at least all the common law states and the British and in the United States and Britain and Canada. We are all, I think, on the same basis, even if it developed. Listen, one of David, one of your cases, when you got, I was very much impressed by this case, and I think you argued this case, when the court gave an order to convene the parliament after by the Queen signed it, and the
Boris
Prime Minister...
Johnson, as Prime Minister, prorogued, that is, suspended Parliament, because he thought that was the best way to get the Brexit deal done.
Yes.
And the Supreme Court unanimously, which is unusual, there were 11 of them, they were sitting on bank, they decided that the advice to the Queen was unlawful because it was unconstitutional, and that although Boris Johnson had suspended Parliament, that was invalid. Parliament was still sitting.
Such an achievement, and remarkable to think there they went much further than we would do, I think, with such a decision.
There are many people in London who think it was remarkable, but that we won't go to. In that case, there was no effective evidence on behalf of the government as to why Boris Johnson had suspended Parliament for so long. And the rumour, I never got to the bottom of it, but the strong rumour was that there was no civil servant who was prepared to swear an affidavit along the lines of what was needed in order to defend the government's case.
Okay. And then, really, for the court to decide that the Queen was misled by the Prime Minister is very, very special, very outstanding. And it happened. So even that we think that we are going forward very bravely, I'm not sure how much we do, but we never thought that the British will do that. But when it's needed, and when you argued the case, it worked.
Well,
so,
but these are profound constitutional questions that are right at the edge of constitutional law. They arise in England, as you've explained. They arise here. They arise, or may arise, in the near future in the United States, because there, the founding fathers were confident, weren't they, that there may well be an imperial president, but the checks and balances would control him or her. And the checks and balances are Congress, which may or may not do its job, and the Supreme Court, 3 members of which have been appointed by the president. So we will see, but it's worrying, very worrying.
It's worrying, always I used to bring as an example that they have checks and balances, not only that they have the Constitution, but as you say, they have 2 houses of Congress, and there is the Supreme Court, so the president cannot do everything. But now we see that it's possible, because the justices were appointed by the president, a system that our government already tried, and I hope will not stay implemented, and political nominations by the president. He controls the Senate and the House of Representatives, so the Congress. So the checks and balances, only the federal system may save it this way or the other.
And you could never be sure what a judge you've appointed is going to decide. It may be that, for example, Chief Justice Roberts
Yes.
disappoints President. He wasn't appointed by President Trump, but
No.
he's generally a
For
Republican
the Republican,
supporter.
yes.
And there's a famous story, isn't there, about Eisenhower,
Yeah.
who said he made 2 mistakes as president, and they're both on the Supreme Court. That was
Warren Court. He warned.
Warren. Yeah, he appointed
he
Warren
appointed
and
Warren.
Brennan as well. I
Yes.
think
Yes.
he appointed. Let's have another question. Yes.
About judicial packing in the UK as opposed to here. It's a very dominant political force here to pack the Supreme Court as well as it is in the US. Maybe you can reflect, because I think this is one difference between the two systems that, for me, happens to be.
It's just not an issue. It is simply not an issue in the United Kingdom that people are appointed because of their politics or because of how they are thought likely to decide cases. I can't remember an example in recent history of that occurring. In the past, in the beginning of the 20th century, perhaps, and there were famous examples where conservative Lord Chancellors appointed very radical people. Stephen Sedley was a radical lawyer who was appointed to the High Court bench. The only example I can think of was John Donaldson, who became Master of the Rolls, Lord Donaldson. He had served as the president of the then National Industrial Relations Court at a very sensitive time for labour relations. And he was thought by the trade union movement to be very hostile to them. And he was not promoted until Margaret Thatcher became Prime Minister. So they're very rare examples, but the English legal system has many, many problems, but that is not one of them. Happily, not one of them. And I won't comment on Israel, but I think it's very, very unfortunate when appointment of judges becomes politically contentious, because it undermines not just the vital function of the independence of the judiciary, but it also inevitably undermines the confidence that the public have in the ability of the courts to render impartial and independent judgments.
Does it have to do with judicial review in the UK as opposed to, let's say, the US or in Israel, where it's a very contentious issue, but how common is a judicial review kind of a judgment that the
No.
UK Supreme Court? Because once you begin to do intensive judicial review, then this inevitably is
We have a very British compromise, which is that the courts cannot overturn legislation, which you can do here, but they can give a declaration of incompatibility, that they think that the legislation contravenes the Human Rights Act, but it's then for the legislature to decide what to do about it. But despite that power, the judges in the United Kingdom have remained politically neutral, or at least perceived as such. And I know many of these judges very well, but I wouldn't be confident as to how they would vote. And I certainly wouldn't be confident how they would decide a case when I argue before them. Whereas I think if you're an advocate in the United States,
of course.
you know very, very well in a constitutional case how at least 7 of them are going to decide the case.
This is why, David, you gave us the reason why we have to stick back to the British system and not to the American system. Yeah. Really, part of the culture was, for independence of the court, that the judges shouldn't be appointed politically. Of course, reality, there is political influence, but the idea was that appointing judges shouldn't be political. This is a very, very dangerous situation, and now they changed the law in Israel. I don't know what will happen with it, but since it will be only from the next Knesset, appointing judges politically means you don't have the judicial independence completely. It means that in order to advance, to make any progress, every every judge in the lower court has to please the authorities and the political branch. It's the separation of
Well,
powers.
we made
go.
two fundamental changes in the United Kingdom in 2009. The first was that the Appellate Committee of the House of Lords, which was our Supreme Court, was abolished, and an independent Supreme Court, not part of Parliament, was established. And that was important symbolically. But the other important function was that the role of appointing judges was taken away from the Lord Chancellor, who was a member of the Cabinet, who, as I said before, made these appointments in a neutral manner. But nevertheless, he or she, always a he, was appointing. And the role was conferred on an independent Judicial Appointments Commission. Yes. And that Judicial Appointments Commission has no political element to it, no involvement. The people who appoint, you have an independent chair, you have judges, you have lawyers, but the politicians are not part of it. They have a role, they are consulted, they can express a view, but they're not on the Appointments Commission. And it works very well. It means you have high quality people appointed. It means you're not appointing people because of the position they're thought likely to take. And the judiciary, I think, in the United Kingdom, others will say if they disagree, still retains the respect of the public more than most public institutions in the United Kingdom.
David, it's heartbreaking for us to hear it, really.
Yes.
I just have to say, what I want to ask you is, please take control of Israel.
No.
You know, some say that.
Yes, please.
I would like to offer a different perspective about that. In the sense
Professor Barak Medina.
Yeah.
if I understand correctly, about 3 years ago, there was an attempt by the British government to repeal the Human Rights Act, or to radically change it in order to be in line with what I read the explanatory notes. They say common sense judging or something like that, and you can understand what it means. And one aspect has to do with public opinion. You know, a similar attempt by our government was responded by a large protest and campaign against this attempt, this so-called legal reform. Whereas, as far as I understand, in the UK, the reaction was much more mild, quite quiet in the public opinion. And the other aspect is, what do you think is the current atmosphere about this kind of populist approach regarding criticism of the court or trying to get away with the issues of the rule of law, whether the Supreme Court would limit the power of Parliament to make these kind of changes to the Human Rights Act and things like that?
Yeah. Well, you're right. There are periodic attempts to repeal the Human Rights Act and to leave the jurisdiction of the European Court of Human Rights, but we're still there. And there is an element of British politics that takes that view. It's normally provoked by a judgment that people don't like. For example, about 10 years ago, the European Court ruled that prisoners, or at least some prisoners, should have the right to vote. And this was, for reasons I really didn't understand, very sensitive issue. And the Prime Minister of the day, David Cameron, said in the House of Commons this judgment made him feel physically sick when he read it, which was quite an extreme reaction, but there we are. And you have these movements every so often. And the Conservative opposition party is at the moment thinking, should we support leaving the European Convention? But there's very few people who object to the British judiciary's interpretation of the Human Rights Act. Is normally an objection to Europe, although the judgments of the European Court over the years have played a very powerful role in civilising English law when the English courts were unable to do so. So it is a problem. There is a populist movement. The Reform Party are popular, no doubt because of the failures of the last Conservative government and the failures of the current government to solve all the problems. You know, a party that comes forward with new ideas is popular. But this is a constant concern. We've had the Human Rights Act since 1998. It's been there for 27 years. I suspect it'll be there for a lot longer.
If I may say so, I think, I read it, it's not my idea, it is involved also with international issues. I mean, they want to be independent, this is the populism. Germany and France will not tell us what to do.
Yeah.
It's our court, it's our national court, and this is part of Brexit and part of the idea to be not connected. But so populism is
The
now
Dean
a
had a
danger
question.
everywhere. The Dean has
It's
a...
completely
the-
related, and that's something that we also discussed earlier. If we are also thinking about the decline of the influence of UK law in Israel or other places, and it seems to me highly correlated to the decline of UK law in the UK. In other words, you mentioned that Brexit has already been mentioned a couple of times, but you know, the UK, the accession to the European Union in 1973 basically hands over, and I'm not a Brexiteer, wasn't a Brexiteer, but hands
Yes.
over a lot of influence, not only to the courts, but the European Commission, so legislation and regulation in newer areas of interest. And also as a student in the 1990s, UK law became much less interesting. I was interested in European Union law because it would apply to some extent with subsidiarity and so on, but it would apply in the UK, but the action was in Brussels. So is that not part of the narrative that we should be thinking of? I mean,
Yes, it is.
Israeli competition law, the statute, is based on the Treaty of Rome, ridiculously, because the Treaty of Rome competition law deals with the European market, not with the domestic market. But of course, all the jurisprudence is based on US law, the Sherman Act and so on. But the statute,
I mean, you're absolutely right. There is an insularity in British political thinking which was demonstrated by Brexit. But the harsh reality for the Brexiteers is that so much of law is international. And notwithstanding Brexit, if you're dealing with international trade, or you're dealing with refugee law, or you're dealing with humanitarian law, you're dealing with many areas of law, you have to reach agreements with other countries. And that's what we in Britain continue to do. And of course, the European Court of Human Rights is not part of the European Union, it's separate, but you know, British people don't always understand that, and there is a strong feeling, why should we have our law determined by people from Germany or France or Latvia or wherever in Strasbourg? That's the feeling. But if you say to them, well, the judgments of those courts have done a great deal to change British law favourably, they will accept the judgments, but they're concerned about the principle. So you're right, it is a concern.
Yes.
It was another question. Did you have another question?
I just wanted to say that I'm not afraid that Israeli politicians would try to deprive prisoners of the right to vote out of self-interest.
They always say it about conditions in the, how are the conditions in the prisons? And,
There's a close interest taken in those matters, no doubt. Let's have another question. Somebody else got a question for us that we can address.
I just had a quick Google check, and I noticed that Israel took the idea of having an Attorney General from the British system. These days, if you want job security, the Attorney General is probably not a job that you're going to
no.
And the idea, as I understand it, is that you should have somebody who can advise the government on what their legal position is. Given that that is such a perilous task these days, do you think that the days of an Attorney General, certainly in Israel and perhaps even in the UK, where the Attorney General is constantly under a lot of pressure, is more or less obsolete now, and that if a government wants legal advice, they can take it internally from the Justice Department or from their own civil servant lawyers?
It's a very delicate issue. I don't know if we can discuss it. No.
So, shall I offer a view, and you can say whether you agree or not?
No.
I mean, it does seem to me this is an absolutely vital position in any legal system, because a government requires independent legal advice as to the legal rights and wrongs of what it is proposing to do. And it should not be relying on civil servants, however competent and qualified they are, who are beholden to that government. They need independent advice from people of stature and status. And Dorrit, that was your role when you were state attorney. You would very often have to tell the government things they didn't want to hear.
Of course.
And you did that.
Usually they didn't want to hear.
No, and you did that very, it was an absolutely vital function that you performed.
Of course. And this is the whole idea. The independence, the professional independence, because those are the people who have to see to it that the government will act and perform according to the law.
Yeah.
I can tell you, if you mention what we took on this issue from the Brits, with here, the Attorney General is really government official. I mean, he belongs to the administration, but it was really always a tradition that he is independent, he or she, now is she, but we never had it before. We have to be independent and not, and of course, to act according to government policy, but according to the law and to direct them how to do. I can tell you that I argued a case years ago where the issue was if the Supreme Court may review Attorney General's opinion, because the idea was that the Attorney General is independent. And we took, I think it was a British case, Postmaster or something like that, that the court doesn't interfere with the opinion of Attorney General. There was an English case like that, and I tried to argue it in the court. This, of course, I lost. They said, I represented the Attorney General at that time, we are deciding this is the final word until it comes to the court. And then the court decides, I think, rightly so. So this is the legal situation which they want to change. Always, governments, politicians didn't like the function of Attorney General or State Attorney being independent. It was always, it's a natural tension. But the question comes to a point that you have to respect the legal opinion, and then it stops there until it comes to the court.
And the value of the institution is that you are performing as a lawyer in the governmental context the function you perform for a private client, that you tell the client, whether they want to hear it or not, what the legal position is. And the Office of Attorney General in the United Kingdom has worked because the person who is appointed is somebody who is generally part of the political class or is a supporter of the government or understands governmental work. So the government has always respected the legal opinion. And there were many things that were said against Margaret Thatcher when she was Prime Minister, but those who worked for her emphasised that however forceful her politics were, and they were very forceful, she was always concerned to ensure that she complied with legal requirements. You know, she might want to change the law, but she respected the judgments of the courts, and she respected the advice that her Attorney General was giving her. And that seems to me absolutely fundamental to the rule of law.
You see, this was my experience, especially with Prime Minister Begin. And he said, he said, well, if you say so, maybe, as you say, he tried to change laws, but he accepted always respectfully the Attorney General's opinion. Not the only one. They all respected, but some were very bitter against it and angry, but they accepted. This was the idea, to accept, because this is the role of the Attorney General. And in the United States, it's a political, of course, a political office. And when it changes, the president elected is a different one. The administration goes, and the attorney general goes. Of course, also the minister of justice. But now he also has orders, the president, against all the offices where someone that was attorney general once or worked for the other administration was working, is to close their offices as revenge. So things become crazy. But thanks God we are not there yet. So anyway, it was a tradition that you have to accept. Sometimes you don't like it, but you have to accept the Attorney General's opinion. And this is sometimes politicians say, well, but my lawyer said different. He said it's possible because I don't know why, Friday evening or Saturday or another day, they were discussing it with their private friends, lawyers. But I think in general, they knew that they have to respect it, always, always.
Well, thank you all for your questions. I've enjoyed discussing with you, as I always do, issues of all natures. Dean, I think that's probably enough for today. Thank you.